How do call recording laws interact with GDPR? Have you ever wondered how call recording laws fit into the General Data Protection Regulation? Understanding this interaction is essential for anyone involved in customer service. Call recording laws treat recorded calls as personal data processing. This means that companies must follow the strict rules set by the General Data Protection Regulation when recording, storing, and using customer calls. These regulations are designed to protect individual privacy while ensuring transparency and security. First, it is important to note that any call recording that involves personal data is subject to the General Data Protection Regulation. Personal data can include voice, name, phone number, or any other identifying information. Companies must have a valid legal basis to record calls. The primary lawful bases include explicit consent, performance of a contract, legal obligation, legitimate interests, and protection of vital interests. Explicit consent is crucial. All parties on the call must give clear and informed permission to be recorded. This consent must be actively obtained during the call, not assumed from a pre-recorded message or silence. If a company records calls to fulfill a contract with the customer, that is another valid reason. Additionally, if there is a legal requirement to record calls, that also falls under acceptable grounds. Legitimate interests can justify recording calls, such as for quality assurance or training purposes. However, these interests must not override the customer's privacy rights. In rare cases, recording may be necessary to protect someone's life or safety, which falls under the protection of vital interests. Before recording, customer service agents must inform callers that the call is being recorded. They should explain why the call is recorded, how it will be used, how long it will be stored, and what rights the customer has regarding their data. This includes rights to access, correction, or deletion of their information. Call recordings must be stored securely. Access should be limited, and recordings should be encrypted whenever possible. Companies should retain recordings only for as long as necessary, following General Data Protection Regulation retention rules. Ideally, recordings should be stored within the European Economic Area or in countries that have adequate data protection standards. From a customer service perspective, call recordings can be beneficial for training, quality control, dispute resolution, and improving the overall customer experience. However, compliance with the General Data Protection Regulation requires balancing these benefits with strict privacy safeguards and clear communication to customers. Failure to comply can lead to fines, legal claims, and damage to customer trust. In summary, call recording laws under the General Data Protection Regulation requiring customer service operations to obtain explicit consent or have another valid legal basis. Companies must inform customers transparently, secure recordings properly, and respect customer data rights throughout the process. This approach ensures that call recording supports customer service goals without compromising privacy rights.